going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hope you guys are having a great day so far. I am under the weather. You can probably hear it in my voice. I think I partied too hard with Mayor last night. I don't know. But so I'm releasing a video night instead of a live, but I will be back tomorrow night, I promise. This is a Judge Simpson case, and yeah, this defendant is getting yelled at by the judge and his attorney. It's actually kind of funny. All right. Yeah. Brain's not working right now, so we're just going to play the video. But before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Court does call the case, People versus David F.
Yes, to my left.
Other side.
Oh, right. Sorry.
And your name, sir? Thank you.
Well, I'll just start. We've been here previously. I thought we were coming for preliminary examination and relayed that to my client. He has discovery, but in the meantime, he got a second case on the same complainant. That has caused this to be converted, in my opinion, to be
A second case on
the same, calling from the jail. Allegedly, everything's allegedly.
the
Calling
witness,
from the jail.
right? Okay, he picked up
Everything's alleged.
right.
So that caused a second case, and in my opinion, a second PCC. So we want a preliminary examination for everything. The people have advised me that they will go forward with or without the witness. I explained all this to my client. He exploded. So
What?
exploded. Well, so I didn't know what I was doing.
Okay.
So, and not fighting for him. And that bothers me more. They can tell me I don't know what I'm doing. That annoys me. But when they say I'm not fighting for them, that goes to my core, since I come from a fighting family and I fight for everybody.
Oh, you do.
No, that just is making me talk to you. I am going to fight, but I got to fight within the rules. And I feel I know them a little bit better.
Counsel, I'm just trying to figure out, he told you you weren't fighting for him?
Oh, for sure. And a lot more too.
Okay.
Yes, that's why I want to just express myself.
No, yeah, that's fine. You know, it's kind of funny to me. When defendants sit up there, they're in custody, they find themselves in more trouble because you were trying to set this, you were fighting for them, you were fighting at me a little bit with this thing. And then has the nerve to say to you, you're not fighting for him, when the reality is, at least allegedly, he's doing the stupid thing that's making your job harder. So that's fine. That's the way he wants to look at it. And the other thing is, and it just amazes me with some defendants, they come up here, they complain about their attorney, and they don't even realize the jewel that they may have representing them, and also don't realize, you know, that fight it wasn't quite anything you did. It's just in your blood.
Thank you.
It is your heritage.
I was carrying.
He doesn't understand that. He doesn't understand that you got to play by certain rules. He just wants to do it his way. So if he wants to do it his way, we'll do it his way. It's not going to turn out real well. So what do you wish for me to do, Ms. Ford?
I'm asking that we set this for a preliminary examination, that you hear from the prosecutor and my client understand that I am really putting forth a top effort. And along with fighting, I actually have skill. So I hope that he understands that.
Well, he also needs to understand that there's going to be a motion for them to proceed by forfeiture, I'm presuming. And that's going to make your case whatever it is. And I know your counsel will be ready to go forward. I know the prosecutor will be ready to go forth, but you understand that, Mr. Abs?
I understand everything.
Okay, then let's set,
In case if she does
Right.
not have discovery,
correct.
Second
So,
one.
just so the court's.
He has discovery on the first one.
on the first case, but not on the
Yes.
second case.
Correct.
How many, there were phone calls, so how many phone calls are we talking about? Because he's gonna have to see all of that, go through it
Correct.
all, so I wanna make sure he has time, so we're not hearing a complaint about that.
As long as possible, within reason.
Yes.
It has to be reasonable.
You didn't have to explain that when I asked you what they going on with our victim.
Oh, excuse me. Let me put this on the record. I did explain that,
All right, you see, he's he's snapping in her ear while he's right in front of Judge Simpson. Like, calm down, man. He's just making everybody mad. Judge Simpson's about to give him a lesson here shortly.
I guess it's hard to understand the various exceptions to hearsay and how in certain instances they can go forward without the victim. I was trying to explain, and then the people gave me a case I haven't read, but I was trying to give him the site People versus Only 327 Mishap 319. Will the court please explain to my clients certain instances where they can go forward without the victim? Excited utterance, mental state, it's.
There are exceptions to the hearsay rule.
The victim-
Given that this is a domestic violence case, there's a statute which would apply, which would allow them to proceed with police testimony. Also, and I don't know if this is the people's intent, they would file a motion to proceed by forfeiture, meaning that because of, the simple way of putting this, because of your wrongdoing, the alleged victim is not present. So the people would, in that instance, not be punished by what is your behavior, or at least allegedly your behavior, Mr. Epps, and so would be allowed to proceed. That's kind of a nutshell version. I mean, there are a little bit more technicalities to it, but I think that
One of
that's,
the technicalities would be MCL 768.27C, and as I indicated, that case, People versus Only 327 Mishap 319, and the
Yeah.
various exceptions to the hearsay rule. That might be excited utterance, present sense impression, mental state of mind.
yeah, I mean, it's all,
And-
it's
and
all
other.
of that kind of thing.
Do I got a
They-
right to cross-examine my accuser?
You know what? Here's the thing, sir. That, if you're talking about the right to confrontation, there's a statute particularly on point where that may be forfeited because of what is alleged to be your behavior. That was the last thing that I brought up.
What do you mean by that, sir?
I am not here to give a law school class, although I could. I'm not, I know, but I'm just saying, that is very technical. That's why you have an attorney.
But I couldn't explain it anymore, and that's why I brought it up.
You just broke down law school for her. How am I different?
No, he did not just break down law school for the attorney. The attorney asked him to explain something because you're obviously not listening to her. Oh, man. All right, here we go.
I didn't break down law school.
Okay,
for
I'll
her.
tell you-
She asked the
We
question.
have told you.
I
I'll
asked
tell
All right,
you
I'm
again.
done. I'm gonna set it for exam.
I'm gonna go to the jail today, so I will,
So
I'll
what's his
tell
name?
you.
Preliminary examination in this matter, because the
Yes.
people may have a motion. I'll set it for September 17th, 2020.
Okay, just one moment, please. Just. Yeah, don't turn your back on it, please.
September 17th, 2024,
Yeah, but he might be if you like.
9 a.m. That's before me.
Thank you.
When?
September 17th at 9 a.m. Oh, wait a minute, excuse
Why
me.
so long?
Uh,
That's 3 weeks.
yeah, September 17th, I can do that, but
Why
not
so
the
long?
8th, because that's the judge's calendar, and I'm a deferred professional. There are some
You can ask
parameters,
for
and you
another
are not
speedy day.
being, oh, that's the new
And-
thing in the jail I'm learning, that I'm being,
And I would anticipate the
Oh.
people's motion, so we'll try to
speedy
hear
trial
that.
is the new
before the-
buzzword in this world, and everything is a violation of that.
Of what?
Speedy trial. That is the new buzzword in the jail.
That has,
Judge Simpson, can I ask a question? What is about what's going on in the jail, speedy, none of this
You
particular
just
about
said
my
speedy.
case.
You just said you had a right to
Like
speedy
this,
trial.
I didn't say, I asked, why so long? I didn't say nothing
It's
about
not
no
a
speedy
violation
trial.
of speedy
I asked,
trial.
why so long? I didn't say nothing about no speedy trial. Like, Judge Simpson, this is where we having a conflict at, sir. I'm asking about my case, and it's everything other than the case. I don't want to talk about nothing but this case.
Okay,
All this
but Mr. Epps,
speedy
hold on,
trial.
slow down. You have two things now which have,
And I
hold
understand
hold on. You asked me a question, but you're operating off of a premise that isn't gonna work. So here's the thing, you had the one case come up. We then had the hearing, there were allegations made, and this is where the complication comes in. There are allegations that are then made that there is phone contact and other communication. I don't know for sure. The allegations have been made. There's evidence of the phone calls. So that's where we are. What the problem then that happens is that leads to additional charges, which then not only is there now this additional felony, that clearly will have an impact upon what the first case that you came. That's what counsel's trying to get through. She's got to get that information. That then leads to other things.
Okay, I understand that. She's not explaining that, sir. That was simple things to understand.
I accept.
Okay,
We're good.
I can't get in between every counsel and attorney and defendant.
Thank you.
And I'm not trying to do that. I'm just trying to explain the process, and I've got to, Mr. Epps, I've got to be fair to both sides. So I got to have it worked out. You would have had an exam before now, had this not come up.
That's understood.
Okay, so that's the reason for the stretch out in time.
Okay,
Also, the other thing, so that you just understand, it's not anybody trying to delay anything. Because of the allegations that come at, and sort of this complicated thing, I won't say it's complicated, but it's a thing where they're going to proceed presumably, and I don't know, they know this for sure, without the witness, your counsel has to try to do some things. I've got to give her time to do that for your protection.
okay.
So it's not trying to stretch anything out. I'm just trying to make sure everybody has an opportunity to do what it is they need to do. It's really as simple as that.
Thank you.
Gotta say one more thing, sir.
All right. Before this defendant puts his foot in his mouth again, I'm just gonna let it play out. There's about a minute left of this clip. This is the guy who got in trouble for making calls from the jail. They revoked his phone privileges. So he's mad that his preliminary exam is taking so long. Yeah, he did it. Well, I guess allegedly. Anyways, you guys have a great rest of your night. I am going to take some cold medicine and go to sleep. So I will not be seeing you tonight, and I'm sorry, but I will be back tomorrow. Until next time, bye.
Yeah, my last court hearing that I will be able to get a hold to her when y'all took my phone.
When, excuse me?
At my last court hearing, y'all took my phone. Y'all told me I'll be able to get a hold to her. I'm not able to get a hold to her.
You should be able to call your attorney.
We've talked,
I'm not able to get a hold to you.
I don't.
but we talked.
That,
Somebody else can.
Oh, he's saying he had to go in the three-way, but we talked.
I'm not able to call her, sir.
you should be able to contact your attorney.
I'm not able to, sir.
Well, did somebody at the jail make sure that can happen? Ms. Ford, check into that if you,
All right.
I'm
We are
done
today.
here, folks. Bond continue.
Thank you.